Good morning and welcome to Coffee with Rich. I'm getting set up here, but as you can see, I'm joined this morning by attorney Andrew Branca. Good morning, Andrew.
Hey, Rich, how you doing, brother?
Good, sir. Let me get this pulled up here, get my feed going, and we will get started. I want to make sure I have it open, so have the video open so we can be able to answer questions. This is my first. Go ahead, sir.
Be on Facebook Live here too, right?
Yes, that's correct.
Obviously, we're interacting over this split screen interface, but let's see.
Get it pulled up here. Hopefully, the Wi-Fi will cooperate.
Yes, okay. Right here on Facebook. There we are. Awesome.
Yeah, when mine comes up.
All right.
Can you see us? I'm still trying to pull mine up.
I can see us on Facebook. I can see the comments. I'm going to welcome everybody in.
Okay, go right ahead. I'm trying to pull mine up. Oh, there we go. Okay. Got some folks jumping on this morning. Let's see. Looks like we got 17 people joining us so far. Just go ahead and say welcome.
Hey, folks, come on in. I see the usual crowd. TC, how you doing? Will, always good to see you. Will, I just heard your interview with Mike Seeklander on American Warrior Society on the podcast. Just catching up on a little listening, and finally got to catch Will's appearance on Mike's show. It was great.
Yeah, it was a great show. Well, Andrew, we got 17 people on. We might as well get to getting. I'll say, yeah, like you said, good morning, Will. Good morning, Rasmic. Good morning to my brother, Jeff Brown out there. Robert, good morning. Good morning and welcome to Coffee with Rich. This is a special edition, the first time I've ever done a split screen, and we're very blessed to have attorney Andrew Branca with us this morning.
Yeah, thank you very much. Thank you. Appreciate that.
I want to say that real quick out of the gate, everything you're going to need this morning is going to be in the show notes. I've got links to all of Andrew's products that we're going to be discussing this morning. And let me say it up front, the disclaimer. I have no financial interest in any of Andrew's products. I'm a believer in them, and I want to share those with you. So this is coming straight from the heart. There's no financial interest in this for me or the American Warrior Society at all. So I want to, like every show, and this show's special, but really no different. We're going to talk about the show that you need to check out. The show that you need to check out is one that Andrew Branca did with us. No shocker there. He did the Zimmerman Files. Andrew, do you remember being on that show? You did Fact versus Fiction?
Absolutely. It was a great show.
And we will talk a little bit about that as we move through. Thank you to the 23 people that are joining me and attorney Andrew Branca this morning. The article you need to check out, and there's links to all this in the show notes, is an article that you wrote, Andrew, about the Terry Thompson versus John Hernandez Denny's parking lot scuffle. Can you tell us a little bit about that?
Yeah, I mean, it's been a while, but of course, I cover a great many of these kinds of use of force confrontations. But my recollection is the aggressor, who would be the defendant in this case, saw a drunk gentleman out in the parking lot of the Denny's urinating in public, decided to scold him for doing that. An argument, then a physical fight ensued, and the scolder ended up putting a chokehold on the urinator and actually choked him to death, killed him, and then, of course, was appropriately charged. And the question is, could his use of force in that circumstance have been legally justified? And it certainly did not appear on the facts as known that there was any way to justify the use of deadly defensive force in that circumstance.
Yeah, and I think his wife was a police officer, if I remember correctly, and I think there's a video of the entire incident.
That's right.
Yeah, and I think she was egging him on, and they're trying to make some arrests, but everybody's been, alcohol's involved, and you're trying to use force. It's probably doesn't always end well that way.
Yep, most of these cases involve alcohol, drugs. In fact, I always get a complaint sometimes when I cover a lot of these this case law and use of force, these appellate court decisions. People say, Andrew, I keep reading these court decisions, and they don't involve people like me. They're full of drug addicts and domestic abusers and alcoholics and pimps. And I'm like, well, yeah, folks, because that's who's in the appellate records. I mean, those are the people who generally go through the court system. They're not people like you. However, the law created because of those cases is exactly the same law that's going to be applied to you if you find yourself in a use of force event. So there's not two sets of laws. There's not laws for the drug addicts and laws for us. It's the same law for everybody. The law that's created to deal with the use of force events triggered by drug addicts is exactly the same law that we have to abide by.
Yeah, I like when you make those comments that what most attorneys and judges are used to seeing when it comes to self-defense law is, bad guy self-defense, right?
Absolutely. Most cases of self-defense are nonsense. These are bad actors, or they were drunk actors or stupid actors, poor judgment actors, whatever you want to call it, who used force or threatened force against another person, clearly without legal justification. But then they get an attorney, they're in court, they want to escape criminal liability. So one of the defenses you can raise from a technical perspective is the legal defense of self-defense. However, those self-defense claims for those bad guy cases of self-defense are generally so defective that they're very easily defeated by a prosecutor. So we end up with a lot of criminal defense attorneys who have a lot of experience kind of half arguing self-defense cases. It's like a football team that has a lot of experience getting to the 50-yard line, but never actually scoring a touchdown, because these cases, claims of self-defense, get blown up so easily through the trial. They never get argued successfully to completion. That's not a fault of the lawyer. The lawyer's stuck with the clients that come to him. And, well, if you're a criminal defense attorney, most of your clients are criminals. That's just the nature of the business. I know a lot of criminal defense attorneys who've done that work for decades, 20, 30 years, and they'll tell me they've had maybe 5 or 6 good guy cases of self-defense in that entire career. They're just not that common.
Yeah. And you're absolutely right. And we see that all the time. So let's welcome some of the folks that are joining us this morning. We got Robert on, we got Tiny on, Kevin, Jared, Sam Day. Good morning, brother. Doug Lightfoot, Semper Fi, sir. Dr. John Eden, Matt. 51 folks on. Please like and share. We're going to go over some of attorney Andrew Branca's products this morning, the ones that I use and enjoy. But I want to start this out like I do a lot of times when discussing law of self-defense, so specifically to this audience here at American Warrior Society. A lot of us are either current or former law enforcement, current or former military, corrections, something where we've had to use force as part of our profession. And I think some of that, once you turn in the badge or once you leave the military, the tendency, and I think that can get some of us in trouble if we do not understand the lawful use of that force. We have an ROE out here in the civilian world, and it's the 5 elements that Andrew's going to talk to us about just in a little bit. And one of the things I want to say is, I'm not bragging, but I'm being very specific. I've used all level of force, from officer presence to deadly force on other human beings throughout my professional career. And I'm not rotting in prison. As a matter of fact, I've never worn handcuffs outside of training or been in the back of a police car unless I was riding with a partner. But that may not be your experience if you're not careful and understand the law of self-defense. And Andrew, I probably want to start with your book. I've got it right here, the 3rd edition. The Law of Self-Defense, the Indispensable Guide for the Armed Citizen. And Andrew, if you could talk to us a little bit about this book and what made you get into this type of law.
Yeah, so it's interesting. I got into this because of an experience many years ago. As a young man, I was a very active competitive shooter in USPSA and later IDPA. And I would go to matches, and because I was a young attorney, just a couple of years out of law school, when people had self-defense law questions, they'd come to me. They'd say, hey, Andrew's a lawyer. Let's ask him what the rules are for use of force. And I'd be like, oh, my God, I don't know, because they don't teach us this stuff in law school, not in any depth. In 3 years of law school, I think we spent maybe 5 minutes on self-defense law. That was it. So I didn't know the answers. So I said, well, I better go to the law library and find out what they have. And they didn't have much. They didn't have much that was prepared. I had to do primary legal research, look at cases, statutes, jury instructions, the very fundamental components of the law. And this was in one state, Massachusetts. But of course, the Northeast is full of small states. And I competed in New Hampshire and Vermont and Rhode Island and Connecticut. And the laws are different there, I thought. So I said, well, I better learn those states too, because I was getting asked questions there too. And the more states I looked at, the more I recognized this common framework of self-defense law. Sure, the statutes are all different for each state, and the cases are different, and the jury instructions are all different, but they're not that different. They all exist using a similar framework. And part of that is because self-defense law is very old law. It's as old as human existence. It goes back thousands of years. And of course, all the American states really adopted our legal structure from England, and England had hundreds of years of self-defense law itself. And it's because of that historical legacy that we have this common framework. About 80% of self-defense law is the same across the 50 states. And it is composed, as I've devised to simplify things, of these 5 elements of self-defense that apply pretty much everywhere. That's the good news. The good news is there aren't 500 elements. There aren't 50 elements. There's only 5 things you need to keep in mind. And the other part of the good news is that if you stay within those 5 elements, because the state, if you claim self-defense, has to disprove self-defense beyond a reasonable doubt, if you stay within those 5 elements, you are very hard to convict. The bad news is that, unfortunately, too many people violate one of those elements themselves and therefore make themselves vulnerable to successful prosecution and conviction. So we wrote our book translating the law from statutes, court decisions, jury instructions through this framework of these simplified 5 elements into plain English to try to inform people how they can defend themselves, how they can win that physical fight in a way that also positions them to win the legal fight that they might have to face afterwards.
Yeah, and I've read the book cover to cover and keep it on my nightstand, like I've said, and several dog-eared pages on there. And we'll talk about some of the specific ones here in a little bit later in the show. But I will also say that I've attended your, I believe it's your level 1 core class. I don't know, at least 3 times probably. And I'm currently watching the DVD. Can you talk to us a little bit about putting the DVD together, putting a course together, whether that's the DVD, the live? I think you have a web-based product out now, Andrew. Can you talk to us a little bit about those products?
So the live in-person course that we've taught maybe thousands of times now all over the country really came out because, well, frankly, different people learn best in different ways. And some people like reading a book, and that's great. We had the book out, but we continued to get requests for in-person classes that we could teach that were really specific to the states in which we would teach the class. So in Tennessee, if we were in Memphis, we teach a Tennessee-specific class, for example, and we did this all over the country. In more than 30 states, this live course is accredited for continuing legal education for defense attorneys, prosecutors, judges, because again, we're not really, as lawyers, we're not really taught this stuff in any depth in law school, and they needed a place to go to learn what the actual law of self-defense was. That was another reason we developed that live in-person class. And then after having taught that hundreds of times, I'd noticed that we had students in the same class 2 times, 3 times, 4 times coming back, and I'd talk to them on breaks and I'd say, didn't I see you here before a couple times? And they'd say, yes, but it's such a fire hose of information, so much information compressed into 6 or 7 hours that it's impossible to absorb in one sitting. And every time I come back, I learn more stuff. I know you must have said it the last time, but I just didn't hear it, or it didn't stick the last time. And that's when we decided to do the DVD version so that people could have a permanent record of the class that they could watch over and over again without having to, sit in the classroom for 6 or 7 hours to refresh their recollection. And that's been pretty popular. The DVD, and of course, we also have it as a kind of a streamed online class that people can access online. For those of us who, frankly, I had to go into my basement and dig a DVD player out of the basement so I could play my own DVDs to make sure they worked. So lots of people don't have DVD players anymore. So we have it as a streamed online option as well.
Yeah, and it's really good. It's extremely thorough. I'm about halfway through right now, and having sat through the one in person, like you said, Andrew, I'm going, I know he must have covered this, but hearing it a different way, maybe a different bit of phraseology, maybe I'm drinking the right coffee that morning. Now that I'm watching the DVD, I'm like, holy cow, okay. That's an interesting little nugget. I don't know why I didn't pick that up before. So I would encourage consuming this product in all those different ways. The book, the DVD in person if you can get that opportunity, or maybe a web-based thing right now.
Now, I should mention, Rich, that we had really cut down on our live in-person classes because the travel was getting crazy. I was traveling almost 50 weekends a year. And mostly we do the live class. We still teach it live, but not in person. We stream it as a webinar now. So there's still plenty of opportunity for Q&A. People can chat, they can ask questions because it is me teaching the class live, but they don't have to go sit in a classroom someplace. They just stay at home, and thank heavens I don't have to spend 2 days flying around the country to teach the class. And we're only doing 3 of those classes this year, just 3. One of them is next Saturday, not tomorrow, but Saturday, April 25th. If folks are interested in learning about that, it's at lawofselfdefense.com, live online, one word. And folks, it's about half the price of the in-person live class because I don't have the travel expense. So I don't, those of you who are instructors, travel instructors, you know this. A good chunk of the money you collect from students goes right to the airline, right to the hotel, right to the rental car company. We in effect don't really ever see that money. So when we decided to do this class in the online streamed format, rather than keep the usual fee, we just cut the fee in half. Since we don't have to pay those travel expenses, and we allow you guys to get the benefit of that. But that's at lawselfdefense.com/live online. Only 3 of those this year, folks. And once those seats are gone, they're gone. So if you're interested, we're not traveling this year to teach classes in person. So it has to be one of these live online classes or a DVD or something along those lines.
Good. And I didn't know that. Yeah, I don't blame you at all. That traveling stuff is, I spent a lot of my adult life traveling around the country and being a diamond member everywhere I went, and I don't enjoy that. Guys, we're going to have some questions. We're going to do a little Q&A with Andrew here in just a little bit. So if you have questions, go ahead and start putting them in the comments section, and we'll come back to it. Looks like Roger is on. Alan Kelly says, yes, once you retire from LE, it is a different environment in the civilian world. I have had to practice a whole lot of restraint. Yeah, I can relate to that, Alan. Many times I'll reach down, like, wish I could throw the lights on and pull this guy or gal over that's doing something inappropriate. But John is on, Les is on, Rudy is on, Jeffrey Young is on, Jeff Day is on. Good morning, folks. And David has joined us from Michigan. 48 people, please like and share. And if you have comments or questions for Andrew, please leave them here. Let's talk about the consult program. I saw you do a live special recently, Andrew, and you talked about your consult program, and I joined almost immediately because I thought it was a really good deal. Can you tell us about that?
Well, the consult program is essentially a way for folks to guarantee that I'm personally available to work on their case if they're involved in a use of force event and are facing criminal liability or civil liability for that use of force event. But most of the cases we work on, people are facing, frankly, most of the cases we work on are aggravated assault cases where somebody's carrying concealed lawfully, they get frightened, they display their gun, pointed at the other person, usually don't fire a shot. But folks, that conduct alone, which we think of as defensive display, prosecutors think of as aggravated assault with a firearm, and it's typically good for 10 to 20 years in prison. And these are people just like us, normal law-abiding people, never been in trouble with the law a day in their lives, and suddenly they're looking at spending a decade or 2 in prison because they threatened someone with a gun under circumstances where a prosecutor doesn't think that was justified conduct. And sometimes it wasn't justified conduct. Or the trouble is it's often ambiguous whether or not it was justified. It's very important for us to remember that if we're involved in a use of force event, we think we know what happened, right? We were threatened, someone's, whatever the case may be, and we acted, we think, appropriately. But nobody else who is judging our conduct after the fact and whose decisions are actually going to control the legal outcome in our case, the police, the prosecutors, the judge, the jury, none of those people were there when all this happened. They don't know what actually happened. To them, what happened is ambiguous. They're hearing one story from you. They're hearing another story from the person who says you threatened them with a gun for no good reason. And they have to try to figure out what the quote unquote truth is. And there is no absolute truth. There's only the truth that they can arrive at by inference from whatever evidence is available, usually the 2 stories they're hearing. So they don't know what really happened. And justice is not about truth, folks. Justice is an administrative process where we try to apply the same rules to everybody. That's what fairness is in the legal context. It doesn't mean we arrive at the right outcome. It just means we got the benefit of the right process. So you're always running the risk that you might have done something perfectly lawful. I tell every case I consult on, I tell those clients, look, if we have to put you in front of a jury, there's a 10% chance you're getting convicted, and you could be the most innocent person I've ever worked for, because that's the uncertainty, the variability in the criminal justice system.
So with the consult program, for those that are members of that, it guarantees that you're going to work on their case initially, Andrew, maybe through some sort of self-defense immunity. What about if it goes to trial and so on?
Right. So the way our legal practice works is we don't take clients directly. If I did that, I'd only be able to take clients in Massachusetts because that's where I'm barred. My legal practice is all legal consultation to other attorneys. So if someone gets in a jam because they've been involved in a use of force event or a threat of force event, they would retain lead counsel in whatever the relevant jurisdiction is, talk with their attorney. If they think it's a good idea for me to consult on the case, their attorney calls me. The client doesn't call me. The attorney calls me. My client is the attorney. And then I consult directly to the attorney, and the attorney takes my professional insight and expertise and applies it to their client's best interests as they think is appropriate. The difficulty we always have in these cases, however, is, to be perfectly honest, folks, I love doing these legal consultations. It's nuts and bolts legal work. It's why I went to law school. It's real law being applied to a real client who's facing real time in prison. But it's among the least productive things I do, by which I mean there's no leverage there. I'm working for one client, helping one client. Almost everything else I do is helping hundreds or thousands of people at a time. When I do a class, like a webinar or a DVD or write a book or just about anything else I do, I'm helping huge numbers of people stay out of prison. When I consult on a case, I'm helping one client. Now, the stakes for that one client are really high. I'm not saying it's not worth it, but it's a lot less productive than most other things I do. And a lot of times we would get calls into the office asking for consultations, and I'd have to say no, because folks, I already work about 7 days a week. So I have very limited bandwidth to free up to work on cases. To solve that dilemma, we came up with the consult program. So if you're a consult member and not just a cold call coming into our office where we typically have to say no because we don't have time, but if you're a consult member, we guarantee we drop everything else. If I'm writing another book, I stop. If I'm teaching a class, we cancel it. Whatever it is, we stop it so that we can immediately begin to work on your case. And folks, that immediate is really important because these criminal prosecutions, they gain momentum. They're like a boulder rolling downhill, and it's much easier to stop a prosecution early in the process, before a prosecutor's become personally committed to the case, when it's still kind of ambivalent and they might agree to dismiss the charges or put you in a diversion program. But folks, once they're invested in your prosecution, that's it. They're not going to go to their boss 3 months, 6 months into the process and say, yeah, you know what, now that we've invested all these resources, I'm reconsidering whether to do that. Forget it. The train has left the station. You're going to trial. But if we can get involved in the first days or weeks after an event has occurred, we can have a lot more impact. So the thing the consult program does for you, it also saves you money and it has other benefits, but really the key value add is that we guarantee our immediate availability to consult on your case.
Yeah. Yeah. When I heard you explain it, and a lot of these self-defense type insurance, I don't know what the appropriate term for those products are, but there's so many exclusions. That's why I've never decided to join it. But when I heard you explain that, you really have removed a lot of the exclusions that most of these products have.
Right. So I should touch upon that because it's important to distinguish between what our consult program is and what these so-called self-defense insurance programs are. And I'm talking about things like CCW Safe, USCCA, Armed Citizen Legal Defense Network. I'm not trying to say anything negative about them. They just do something different. What they do is they promise to pay for your legal expenses comprehensively if you're charged or facing criminal liability for a use of force event. Our consult program does not do that. Your legal expenses are your own, except for me. My expenses are covered. My availability is guaranteed, but you still have to pay your attorney yourself. So we don't cover that. Those other programs do. That's a value they bring to the table that you ought to strongly consider. And in full disclosure, Law Self-Defense is partnered with CCW Safe. I'm personally a member of CCW Safe for that benefit. But because those companies have that much greater financial exposure, because it could cost them hundreds of thousands, even millions of dollars in legal costs, they do have exclusions. For example, some of them won't cover you if you had a couple beers before you defended yourself, because they say, well, we don't want to cover people who go into a bar and get drunk and then shoot somebody. Some of them don't cover domestic violence events. They just choose that as an exclusion, something they don't want to cover. In the consult program, we have no restrictions, no conditions, no exclusions. I just don't care. Now, if you're drunk when you shoot somebody, that's going to play a role in your defense. Trust me. But you'll still get our consultation. We won't deny you the consultation under any circumstances. You might not like what we say if you're drunk when you shoot somebody, but you'll get that legal consultation. Domestic situation, if you're carrying a gun where technically you're not supposed to be carrying a gun, like in a posted store, for example, that says no guns allowed, a lot of these self-defense insurance programs won't cover you because you're engaged in unlawful activity by doing that. You're trespassing at the very least on private property. I don't care about any of that. So if you're a consult member, regardless of the circumstances, you get that consultation to which you're entitled as a member.
Yeah, like I said, and that's when I went, okay, I can work with that. Thank you, Andrew, for that really clear discussion on that. And if you have any questions about Andrew's consult program or any questions for Andrew, leave them in the comments section. We're going to be coming back to that here in just a second. But Doug Lightfoot made a really interesting point here. I want to scroll back to see it. Excuse me. Doug says, I have testified multiple times in several different courts over the years, but always on the side of the prosecution. We can all benefit from Andrew's training and experience, especially if we are the defendant in a criminal or civil case. And that's obviously that's my experience too, as an investigator in the Marine Corps and handling a lot of really high profile cases. I was always on the side of the prosecution. I'm always on the side of the prosecution as a police officer, as a corrections officer. So I have zero experience on being the other side of that coin. And that's why I really defer to what you say, Andrew, on that.
Yeah. So of course, there's advantages to being the defendant. The biggest advantage being the state has to prove you guilty of the crime beyond a reasonable doubt, which is a very high threshold. And in a self-defense case, they have to disprove self-defense beyond a reasonable doubt, which is a very high threshold. Unfortunately, that's about the only advantage you get. Because the prosecution has, for all practical purposes, infinite resources to bring to that legal fight. And just imagine if you were getting into any other fight, any other battle, and your enemy in the battle had infinite resources. That's a tough battle to win, unless you can come close to matching those resources. And frankly, that's one of the reasons that these quote-unquote self-defense insurance programs have such appeal, because they provide the guarantee of those resources. And folks, these cases get really expensive. An aggravated assault with a firearm case, the retainer for the lead attorney is typically $30,000 to $50,000. That's before you get to trial, folks. That's not the trial cost. That's before you get to trial. You go to trial, it's a multiple of that. If you've killed someone and you're claiming self-defense and you're facing manslaughter or murder charges, you'll easily go through $150,000 pre-trial before you get to trial. And then it's a multiple of that when you're actually at trial. So hundreds of thousands of dollars is easy to do. Now, what do you do if you don't have that money? Well, then you fight with the resources you have. But I can tell you that a $30,000 legal defense is vastly inferior to a $300,000 legal defense, not just in terms of the legal expertise you can bring to bear, but the additional legal expertise in the terms of consultants like me to work on your case, in terms of your lawyer having a team behind him. And that team can make all the difference, folks. Just to give you an example from the George Zimmerman trial, for example, if you saw that trial on TV, you only ever saw Zimmerman's two attorneys, Don West and Mark O'Mara. Those are the only people you ever really saw in the courtroom. But I can tell you there was 10 or 15 people supporting Don and Mark in that case. And that support allowed them to do things, for example, like identify a potential juror who said, oh, I'm not biased about this. I'll be completely open-minded. Just put me on the jury. I'll be completely fair. That guy had a Facebook page effectively arguing for the lynching of George Zimmerman. If that guy had made it onto the jury, Zimmerman could never have been acquitted. That guy would never have acquitted him. If Don and Mark were working alone, they can't work 24 hours a day, folks. They got to sleep sometimes. But because they had staff who could check the Facebook pages of the jurors. They caught this guy, kept him from getting on the jury. If you don't have those kinds of resources, you don't get that kind of filtering of prospective jurors, and you could find yourself in a very bad situation. So that's the advantage that comes with having those resources available through these programs. I talk so much, I might have lost track of the original question, but the resources that the prosecution can bring to bear. You want to get as close as you can as possible to being able to match those resources. I can tell you that because I've spoken to George Zimmerman's attorney, Don West, about this many times, their billable hours, the legal costs for the attorneys alone in his trial were close to $2 million, folks, $2 million. And by the way, when you look at these self-defense insurance programs, I do urge you, if they have a cap on coverage, and many of them do, be careful about that, because if the cap is $150,000 or $250,000, that sounds like a lot of money. I know it is a lot of money. It's not a lot of money in a murder trial, folks. You'll burn through that quick, and then you're left to your own devices if that was the cap on your coverage.
Yeah, that's absolutely correct. And I, again, as an investigator for the Marine Corps, the pockets of the Department of Defense are very deep. And when I would get tasked on an investigation, there was no limits to what I could do, no limits to where I could go or what I could bring to bear on it. So yeah, it was as deep as you wanted to go and spend whatever you wanted to spend to get that conviction. So let's take some Q&A now, Andrew, if you're ready.
Sure, absolutely.
All right. Let's see. Let's see. Excuse me. Gene says, we are USCCA members. Can you say anything about their product without getting yourself in trouble?
Yes. I would say that USCCA is one of the programs that has caps on coverage. So I know they have multiple levels of membership you can sign up for. And it's important to distinguish between the civil coverage and the criminal. So most of these programs will say they'll give you $1 million of coverage for civil liability. What that means is if someone sues you and wins against you in that lawsuit, they'll cover $1 million of damages, the money you would otherwise have to pay to that person. That's different than the caps they place on criminal coverage. For criminal purposes, what they're talking about is not what you might have to pay some other person if you lose, because if you lose in the criminal context, you just go to prison. What they're talking about is the amount of money they'll provide for your legal defense during the battle itself. And I know USCCA, don't hold me to the numbers, but it's something in the range of $150,000, $250,000 is the cap on their coverage. And that has two implications, folks. If there's a cap, first of all, that limits the coverage in your trial. So if you're in a murder trial, you'll burn through 150, 250 in no time. But it also means that if you're convicted at trial and you want to appeal, there may be no money left under that cap for an appeal. So you could be left completely at your own devices. Or if you have a hung jury, and which is a win for a defendant, by the way, a hung jury is a win. It's anything other than a conviction is a win. But if it's a hung jury, the prosecution can just decide to try you again. Well, if you burn through all your money in the first trial, is there any money left under the cap for a second trial? Probably not, right? So I would be sensitive to those caps. Now, all these programs have strengths and weaknesses, advantages and disadvantages. I'm partnered with CCW Safe. They have weaknesses too. They all do. So we never recommend any one program universally. Everyone has to look at these programs, hopefully in an informed way, and choose the one that best fits their particular circumstances.
Thank you, Andrew. This next one comes from Rudy. Rudy says, Florida statute talks about forcible entry as one prerequisite for using deadly force to defend yourself in your home. If the criminal finds one of your doors unlocked, can you still argue that he made a forcible entry?
Probably not, but we should clarify what Florida law means by that. So there's different justifications for using deadly force against another person. One is if you're facing a deadly force threat from that person. That's just straight up self-defense. That applies if you're walking down the street, driving in your car, in your home. If somebody's threatening to kill you, they're an imminent deadly force threat. You can use deadly defensive force. Now, in the context of your home, there's often laws that lower the threshold that has to be met before you can use deadly defensive force. So they might say, well, if someone's forcibly and unlawfully entered your home, we will legally presume that you were facing a deadly force threat. So you don't have to make that case anymore. You don't have to say, I saw a gun in his hand. The law will presume that he's a deadly force threat. But that doesn't mean you lose traditional self-defense. So if you're in your home and someone comes in and they have a gun and they're threatening you just like they might on a street, well, you have all the same rights to self-defense as you do on the street. If they didn't forcibly enter, you might not get the special benefits of those special provisions that presume he was a deadly threat. You might have to be able to articulate, well, I believed he was a deadly threat because he had a gun, for example. So you don't lose traditional self-defense just because you're in your home. If you're in your home, you're facing a deadly force threat, you can defend yourself just like you always would, but you may not get the benefit of a special provision like a legal presumption that the person was a deadly threat unless they've triggered those legal presumptions. And in many states, that requires a forcible entry, and merely pushing a door open wouldn't meet that condition. Now, that's a good argument, folks, for keeping your darn doors locked, okay? Compel that bad guy to break something to get in, because there can be innocent explanations for why someone's in your home unlawfully, but there's no innocent explanation for why they broke something to get into your home, right? That strips any ambiguity out of the situation if they had to break something. So keep your doors locked. We just covered a home invasion in a Chicago suburb that happened just a few days ago. A couple guys came up to the house wearing COVID masks and gloves. The first thing they did, folks, when they stepped up to that house was try the front door. Because if it was unlocked, they were just going to walk in. And those guys had a bag with them with zip ties and a blowtorch. What do you think they were going to do with that stuff? And inside the house is a father, a mother, and 2 young girls. What do you think they were going to do in that house? So lock your doors. And this guy had his door locked, so they couldn't just walk in. They had to ring the bell. They had to wait for him to open the door. So at least he was able to confront them right there in the doorway, as opposed to if he's taking a nap and his kids are running around the house and these guys just stroll into the house, grab one of his kids. That's a very different defensive situation.
Yes, it is. John asks, Andrew, why did you choose CCW Safe as opposed to others?
The 2 major reasons are that CCW Safe does not have a cap on how much they'll pay for your legal defense. So they will pay whatever it takes. If it's a $500,000 trial, $1 million trial, they'll cover it. If you get a hung jury and you get retried, they'll cover the retrial. If you get convicted and you appeal, they'll cover the appeal. So there's no limit, in effect, on the legal expense coverage that they'll provide. So that was one huge factor, because I know how expensive these cases are, and I don't think $250,000 is enough coverage if you've killed somebody in self-defense and are getting prosecuted. The other key factor was they have as their national trial counsel, their corporate attorney for all practical purposes, Don West, who was one of George Zimmerman's attorneys. And I watched every minute of that Zimmerman trial, and the team of Don West and Mark O'Mara, Zimmerman's defense attorneys, they waged a perfect legal defense in that case. There was 0 mistakes. And they often say afterwards when they're interviewed, they say, yeah, well, we won Zimmerman his acquittal, but we should have won. He was innocent. There was clearly self-defense. And that's all true. They should have won that case, but they could have screwed it up. They didn't. And I see plenty of attorneys do screw it up. So I think the world of Don West. And if Don West is advising on your case, you are in an enormously stronger position than if he weren't available. And if you're a CCW Safe member, he's available. He's part of the package.
Yeah, absolutely. Our good friend TC Fuller says 20 years as a Fed, nobody ever said that's too costly. And I never heard that either. And I will tell you too, on your subject of prosecutors, I worked with some terrible prosecutors that bungled some really good cases I'd put together. So I pray that if I ever get in a jam, I'm going to get one of those prosecutors. But
yeah, I mean, lawyers are like anybody else, right? And any professional, any craft, they're on a bell curve. And a lot of prosecutors are world-class prosecutors. A lot of public defenders, folks, are world-class criminal defense attorneys. So, people seem to have this perception that public defenders suck. Some of them do, but some of them are just awesome. One thing that's always true of public defenders, however, is they're vastly overworked. So you're not their only client. They're working a ton of cases, unfortunately, which means the amount of attention they can give any particular client is relatively limited. But just as there's attorneys on the excellent end of the bell curve, folks, there's attorneys on the not so excellent end of the bell curve too. That's another thing to watch out for these self-defense insurance programs. If it's a type that tells you what attorney you can have, tells you who your attorney is, it has to be from their network, for example. To me, that's a huge red flag. I do not want someone else picking my attorney for me, because How do I know if that attorney's any good? And what's their financial incentive to pay a lot of money for an excellent attorney? Or if they can lawfully meet their obligation to you to pay a little money for maybe a not so excellent or experienced attorney. I want to pick my own attorney. So unless the plan allows for that, I'm not interested.
Yeah. So good morning to the 70 folks joining us. If you're just now joining us, we're on with attorney Andrew Branca, the author of The Law of Self-Defense, 3rd edition. And we're doing a little Q&A with Andrew for as long as we can keep him on this morning. This question from John, Andrew says, can you have more than one insurance carrier to stack your coverage? Are you aware of that?
Well, you can. I'm not sure it's a good idea. Anybody who's ever had to deal with multiple insurance companies on a claim knows that they all tend to point fingers at each other, right? Yeah. Oh, no, get your coverage from that one. Oh, get your coverage from that one. Nobody wants a right to check themselves because they can always point to somebody else. And that is a risk that can occur if you stack your self-defense insurance coverages. Now, do I know that they would do that? No, maybe they would work cooperatively and share the cost, or, I mean, who knows, but that's a decision that's not in your control. So that can be a complicating factor. There is a question here from Alan I wanted to address. He asks, in our consult program, do we have a list of competent attorneys in various states that we recommend? We do. We work with a lot of attorneys, of course, in most of the states, perhaps not all 50. I'm not sure we've done cases in all 50, but we get a lot of exposure. We work with a lot of attorneys. We tend not to recommend attorneys until you have a need. So often people ask us, oh, can you recommend an attorney so I can keep his business card in my wallet in case 10 years from now I'm involved in an event? We don't do that because the attorneys, frankly, don't like it. They start getting calls from people who are not, in fact, prepared to start paying legal fees to the attorney. But if people are members of the consult program, we can certainly recommend attorneys. The most important thing, however, is say you choose your own attorney. Part of what we do is we talk with that attorney. So we can give you a sense of, does it sound like this guy actually knows what he's talking about when it comes to self-defense law? Because again, most attorneys don't, folks. Even most criminal defense attorneys, as we said at the start of the program, don't have much experience arguing good guy cases of self-defense. So we can definitely give you a sense of whether or not it sounds like to us that this attorney knows what he's talking about. And if it sounds like to us he doesn't, we'll tell you that. You can still have that attorney. That's your choice to make, but we'll help you make an informed choice.
Thanks, Andrew. Let's see here. One of the questions that I had, and I saw somebody pose it a moment ago, was a lot of the insurance providers only cover you if the use of force involves a firearm. But I believe your consult program covers you, the person, whether your use of force is an arm bar or a firearm or something like that. Is that correct?
Yeah, I don't care what it is. If it's a gun or a knife or a brick or an anvil dropped from a great height, it doesn't make any difference to me at all. Also, it doesn't make any difference to me what state you're in. So a lot of these self-defense insurance programs have gotten heat from a number of states, New York, Washington, one or two others that are calling them murder insurance and banning these companies from providing their services in those other states. We don't have that condition on the consult program because we're just a very traditional prepaid legal service. We're not covering your legal expenses generally, right? I made that point earlier. All you get is a guarantee of my availability to work on your case. And of course, you've prepaid for my services, so there's no cost for me. But because it's just a traditional prepaid legal service, we're not subject to those kinds of constraints by those states that tell you you can't have USCCA or you can't have CWR Safe in our jurisdiction.
Gotcha. Okay, Andrew, a couple more questions here. This is one from TC that came in last night. He says, silencers, what kind of impact do they have, if any, on an otherwise righteous shoot? Do they potentially enhance sentencing should you fail in your claim of self-defense?
So my expertise is in the actual use of force itself, not in sentencing enhancements. Now, of course, gun sentencing enhancements are very common. You use force against someone, that use of force is determined to be unlawful. So you're guilty of that. And then you use the gun to do it. Very common to have a gun sentencing enhancement. Sometimes the gun sentencing enhancement carries more time than the underlying criminal charge. Not at all uncommon. So you can be convicted and sentenced to 10 years for an aggravated assault and have 20 years mandatory minimum because of the gun sentencing enhancement on top of it. So that can be a concern. I'm not aware of any sentencing enhancement for using a suppressor as opposed to just generally having used a firearm. I don't believe a suppressor adds anything, assuming, of course, it's lawfully owned. If it's unlawfully owned, well, then you're looking at federal time for having, unlawful possession of a controlled device. But here's the risk. Even though it may not carry a sentencing enhancement in the black letter law, it's important to remember that the criminal justice system is not some kind of giant computer where you load facts into one end and a perfectly objective algorithm cranks out justice out the other end. The criminal justice system is built on people, and people are making subjective calls about how they want to proceed, how they view evidence, how they view the reasonableness of what you're doing. And remember, the jury, who's ultimately going to be the decider of your fate in that legal battle, they're unlikely to be a panel of 6 or 12 people who are highly experienced with firearms, much less suppressors. And if the prosecutor one of the conditions of lawful self-defense is that your conduct was reasonable. That's one of the 5 elements of self-defense. Well, is use of a suppressor in self-defense reasonable? Can a prosecutor argue that, ladies and gentlemen, sure, if he had just shot this guy, that would be fine, but he shot him like an assassin using a suppressor? Is that an argument a prosecutor can make to a jury? Absolutely. People always ask me, if I do this or that or use this or that, can that be used against me in court? Folks, anything can be used against you in court. If by used against you in court, we mean, can the prosecutor talk about it in front of the jury in an effort to make you look guilty? They can talk about anything, folks. Those funny stickers you put on your car, keep honking, I'm reloading, we don't call 911, terrorist hunting permit, the Punisher backplate on your Glock, the fact that you used a suppressor on your gun, they can talk about all of that in front of the jury in an effort to make you look bad. Might it sway the jury? Frankly, if you have a really robust claim of self-defense, it probably doesn't matter. But if you have a really robust claim of self-defense, you're probably not going to trial anyway, because they do have to disprove your claim of self-defense beyond a reasonable doubt. But what if your claim of self-defense is not robust? What if it's marginal? Could having that sticker or that backplate or that suppressor push that little bit of difference over the edge to get a jury to convict you? It's possible. Yes.
Yeah, I like that answer. This is an interesting question here from Jared. He says, as far as interstate truck drivers, because they sleep in the cab of their truck, is that considered for legal purposes their domicile or not?
I would certainly make that argument. Absolutely. So the definition of domicile is a dynamic definition, meaning it's not just your home, but it follows you. So if you're traveling and you're staying in a hotel room, while you're in that hotel room, that's your domicile. Now, only the parts of the hotel to which you have right of exclusion, like the room itself, not the common areas like the hallway or the lobby of the hotel. That's not your home. Like your living room would be your home in your actual residence. If you have an RV, recreational vehicle, while it's parked in storage in your backyard, that's just a non-occupied vehicle. It doesn't have any special status. But if you're actually using it on vacation, you're living in it on vacation, well, then that becomes your domicile while you're on vacation. If you're camping in a cloth tent, that tent becomes your domicile while you're camping in that tent. And I would certainly argue that the same analogy applies to a trucker who has a interstate truck with a sleeper cam and he routinely sleeps in the truck. While he's doing that, I would argue that's his domicile. Absolutely.
Good. Elke has a question here. It says, will it look bad to the jury that you're prepaying for a self-defense homicide expert?
Well, again, a prosecutor can talk about anything in front of the jury, pretty much. So you have to assume if you're a member of USCCA or CWR Safe or my own console program, they may well be free to talk about that in front of the jury. But what we always have to consider is not just can they talk about it, but how damaging is that likely to be to you? How easy is it for you to offset that? It's pretty hard for a prosecutor to argue that it's some indication of malice on the part of the defendant that he has a legal defense. That's part of the system. You're allowed to have a legal defense. You're allowed to educate yourself on the law. After all, didn't the prosecutor himself go to law school to get educated on the law? If that's a bad thing, isn't he a bad actor? So it's just not something that carries very much weight.
Good. Andrew, I want to be respectful of your time. I've kept you on here for 50 minutes. I got 2 more questions for you, then we'll close it out, okay? This one comes to us from Robert. He says, when defending yourself with a knife, should the attacker become the receiver of a deadly cut, what consequences might the defender face?
Well, you might face life in prison. I mean, you face the consequences, the potential consequences you face anytime you kill somebody. The consequence is potentially spending the rest of your life in prison if it's found that your use of force, deadly force, was not justified. Then it's just a murder, folks, or perhaps a manslaughter or one of the other killing charges. That's the potential downside. So you have to be prepared to wage that legal battle to show that you have the required 5 elements of self-defense and that your use of that force was lawfully justified. Self-defense as a legal defense is extremely binary, folks. It's like an old school light switch. It's either on or off. You qualify or you don't. If your conduct falls within the legal bounds of self-defense, you have 0 criminal liability for that use of force. Your use of force was simply not a crime. It was legally justified. However, if you fail to qualify for self-defense, and that just means missing any one of those 5 elements, folks, any one of the required elements, if it's not there, if it's disproven beyond a reasonable doubt, your claim of self-defense collapses entirely. And you don't just have some legal liability, you have 100% legal liability for that use of force. So really important to make sure you do in fact qualify for self-defense. You meet those conditions, you check those boxes. If you do that, very hard for a prosecutor to prove you guilty beyond a reasonable doubt. You make yourself hard to convict.
Yeah, and I'll say that Andrew has mentioned the 5 elements of self-defense. Again, I'm going to refer to the book, Innocence, Imminence, Avoidance, Proportionality, and Reasonableness. And like he's saying, could you talk briefly about it's an affirmative defense going into it? I think that's a very important distinction for the layperson to make.
Yes. So I don't like the phrase affirmative defense for reasons I'll explain in a moment. But before I get into that, folks, I talk about these 5 elements. We actually have a totally free, doesn't cost a penny, infographic that you can download, 1-page PDF infographic. It's this thing I'm holding up here, but it's a PDF when you download it. You'd have to print it out yourself. But it has a brief explanation of each of the 5 elements. So you have at least that working knowledge. I put it in the comments here, lawofselfdefense.com/elements, and you can download that PDF of those 5 elements. I don't like the phrase affirmative defense for a rather technical reason. Today in America, once you've raised the legal defense of self-defense, the prosecution has the burden of disproving self-defense beyond a reasonable doubt. But that was not always the case. Decades ago, it was very common that once you raised the legal defense of self-defense, you had the burden of proving self-defense by a majority of the evidence, which is a vastly different threshold. In the old days, you had to show by 51% of the evidence it was self-defense or you got convicted. Today, the prosecution has to show by, let's make up a number, 98% of the evidence that it wasn't self-defense in order for you to be convicted. Now, traditionally, the phrase affirmative defense means that older model. An affirmative defense was one you had to prove. That's no longer the case in America. You don't have to prove self-defense. The prosecution has to disprove self-defense. What's still true about self-defense, however, is that you have to meet what's called your burden of production. You have to be able to show there's some modest amount of evidence, really low threshold. Really, it's a more than 0 evidence threshold. But you have to show there's some evidence in support of each of those required elements before you're allowed to argue self-defense in the first place. It's important to understand that trial courts, one of their key functions is as a gatekeeper to control evidence and legal arguments that can be made in court. We've all seen cases where a judge has ruled that some particular piece of evidence is not admissible in court, right? The warrant was bad or it's prejudicial or whatever the case might be. It's not relevant to the case. He excludes that evidence, which means the jury will never see that evidence, right? Well, the same is true of legal arguments. The judge decides what legal arguments are allowed. You can't just walk in and make any legal argument you want. Your legal argument has to be based on some actual evidence. And that's true of self-defense. You don't have some fundamental right to argue self-defense in front of the jury. You have to be able to show that there's evidence supporting self-defense, meaning evidence in support of each of the required elements of self-defense. If you fail to meet that burden, the judge can tell you, we're not going to let the jury hear the words self-defense in this trial. A lot of bad guy cases of self-defense get blown up right there because their claim of self-defense is nonsense. One or more of the elements has 0 evidence in support of it, so the judge simply doesn't allow them to argue self-defense at all. For us, we have to make sure we can meet that burden of production. We can show at least some evidence in support of each of those 5 elements in order to be allowed to argue self-defense in front of the jury at all. Now, that might horrify some of you, but the good news is for good guy cases of self-defense, this is generally not hard to do. I only mention it because the consequences of not meeting your burden of production are catastrophic. Because keep in mind, self-defense, when you claim self-defense, you're not saying, it wasn't me. I didn't do it. I wasn't there. I have an alibi. You're saying it was me. I did it. I shot that guy, but I did it with the legal justification of self-defense. Well, if you don't meet your burden of production and you're suddenly not allowed to argue self-defense in front of the jury, all that's left of that statement is the confession, the first half, right? You're conceding that you fired the shot that killed that guy. That is not a position you want to be in.
No, it's not. Let's see. The last question I want to is one that actually I have here. I had some points about don't listen to your martial arts teacher when it comes to self-defense. I've seen a lot of bad advice given out in my years in martial arts, but I wondered if you could, Andrew, is there a difference between a fight and an assault? And what is the difference?
I guess there's a difference. If you're involved in the confrontation, you'll have your own perspective. Whether there's legally a difference, again, these situations tend to be ambiguous. Of course, if we're claiming self-defense, what we're claiming is, hey, we're just the innocent party, and that other person's the unlawful aggressor. They initiated the physical conflict, so we were assaulted. All right, assault literally, or battered. Assault literally means you're put in fear of some harm. Battered means you were actually struck by the other person. So if you're claiming self-defense, you're inherently saying, well, that guy was the initial aggressor, he was the assaulter, he was the batterer, and I was simply defending myself. Is that going to be believed, or are other parties going to say, well, it looks to us more like a fight, by which they might mean something like mutual combat. Mutual combat, of course, is when 2 people agree to fight to settle their differences. The classic example would be 2 guys in a bar, right? Let's go outside and settle our differences, right? Pair of idiots. Well, if you're a mutual combatant, if you agree to engage in physical conflict, you're both mutual aggressors. You're both initial aggressors in that confrontation, and neither of you can justify your use of force as self-defense. And frankly, that's a lot of self-defense claims get blown up because that's exactly what it is. It's 2 guys who decided to have a fist fight. Then the cops show up, they get cuffed, they're going to face charges. They try to escape criminal liability by claiming they're the innocent party. They were just acting in self-defense. But there's a ton of witnesses from the bar saying, no, they just decided to go outside and have a fight. That's not self-defense, folks. That's mutual combat. That's just having a fight. You just assume whatever criminal liability may flow from that.
All right. So I've had you guys on here for about an hour now. Thank you to the 60 or so folks that joined us this morning. I really appreciate it. I want to thank Attorney Andrew Branca being on the show this morning to discuss the Law of Self-Defense 3rd edition, his book, his DVD set. He has state-specific guidance. If you're looking for what is the specific self-defense instruction in your state, he has that available for you as well at thelawofselfdefense.com, as well as his consult program. So, Andrew, thank you for coming on the show this morning.
My pleasure, Rich. For those who might be interested in the consult program, the easiest way to learn more about that is just point your browser to Law of Self-Defense. I'll put it in the comments too. lawofselfdefense.com/consult, and it'll take you to the page that has all the information about that program. It's not expensive, folks. I think it's $15 a month, something like that, for me on your case if you're involved in the use of force event. So if that's worthwhile to you, welcome aboard.
Yeah, and all the notes are going to have got links to an article Andrew wrote for us on the AmericanWarriorSociety.com. I've got a link to the show that Andrew did breaking down the George Zimmerman, Trayvon Martin case. So if you're interested in all that, it's in the show notes today. And please check out AmericanWarriorSociety.com for all your defensive and tactical needs. So thank you again, Andrew, for coming on the show. And guys, stay safe out there.
Remember, folks, you carry a gun, so you're hard to kill. Know the law, so you're hard to convict.
Bye, guys.